Hey, it's James, Fathers, Rights, and Resources, hashtag how I got custody. I talk about Civil Rule 11 to hold liars and lying attorneys accountable, or at least to let them know and check them that you're not going to tolerate their bullcrap. But Civil Rule 11 is a federal rule for federal court, and most states have adopted it. Some states don't have exactly Civil Rule 11, the numbering system. So I'm going to show you how to find the equivalent of yours in your state. So here we go. So I just Googled Civil Rule 11 federal court. In federal court, the rules are the same in every single state in America because it's federal court. It's the national court system of the federal courts. So Rule 11 talks about signings of pleadings, motions, and other papers. So let's click on that. And when you go in there, it says every pleading and written motion must be signed. Now, when you sign a pleading, if you're an attorney or a party, your signature automatically means by presenting to the court a pleading written and then signed, whether signed by or filed, whatever, you're guaranteeing that it's not being presented for any improper purpose such as to harass, cause unnecessary delay, or increase the cost of litigation. You're guaranteeing, number two, the claims and defenses and other legal contentions are warranted by existing law, and that it's factual and there's evidence to support it. Then it says, and then the person who wrote it and signed it made seized any reasonable opportunity for further investigation, or you'll have evidentiary support or further investigation. So, and the denials are warranted on the evidence. Okay, so if Civil Rule 11 has been violated, and I'm going over the rules so that you understand it first. Civil Rule 11 has been violated, then there could be a motion for sanctions. So they can be punished if it's violated. So if somebody signs something, everybody has to sign a pleading, and the signature guarantees that it's not presented for an improper purpose to abuse the system against somebody, that it's warranted by existing law or a non-frivolous argument. If there's no law, I have a guy who the baby's mom is trying to get him for money for that she thinks he owes him before the child was born. That there's no law that allows that. It's frivolous. So they're violating Civil Rule 11 by asking for that. Or if they come in and ask for alimony after the divorce is over and they had a chance, it's too late for that. The divorce is over. So that document is violating Civil Rule 11. Or if they're just lying about you, saying you're a monster and they know that they're not, and the attorney didn't investigate the thing, the attorney, some states, the Civil Rule 11 says after a reasonable inquiry. Or if the factual contentions are not true. So that's the federal rule for Civil Rule 11 in all federal courts. And if you're in court and you don't know what the Civil Rule 11 is in your state, you can say, after the spirit of Civil Rule 11 in the federal court, we should be sanctioning these people. Now, let me give you an example of how it's exactly the same in a state, in my state, in Washington. So if I go to Washington state courts, like a lot of courts, they have forms. They have forms here. This is court opinions and published opinions. So here's rules. And in Washington state, there's a freebie for some of you guys in Washington. The court rules are divided into the statewide rules for the entire state or local rules for each county. So if we go into statewide rules, we go into the rules for Superior Court, and we're going to civil rules. We're not in criminal court. We're not looking up at guardian litem rules. We're not looking up, juvenile court rules. We're looking for the general civil rules for civil court because family court is in civil court. And we scroll down, Civil Rule 11, signing and drafting his pleadings. So, again, this is going to be almost exactly like the statewide rule. Now they're publishing PDFs online because they don't want to maintain, a direct link. So, it says kind of the same thing. Every pleading and motion of a party shall be dated and signed. And then it says the signature of a party. Now, you can read my Civil Rule 11 or watch my Civil Rule 11 video on YouTube also, where I go into this a little bit further. So the signature constitutes the certificate that the party or attorney has read the pleading and motion or legal memorandum, and to the best of their knowledge, the information and belief formed after an inquiry reasonable under the circumstances. So an inquiry reasonable basically means the attorney has to investigate. Okay, the attorney can't just believe their client. Oh, he's a monster. Okay, where's some proof? Where's some pictures? Where's some evidence? But family law attorneys violate this all the time because they don't do a reasonable inquiry. And if you look up case law on this, it says that they can't just believe their clients on the surface or prima facie allegations. That's not good enough. They have to make a reasonable inquiry under the circumstance. Now, if they go into ex parte, they can say, oh, my client's all scared and she's sweating, I believed her. But generally, they have to spend some time investigating. Just like a prosecutor won't prosecute a case because they can't find the dead body and they don't have enough circumstantial evidence. They have to make an inquiry that their case or their claims are reasonable. So let's go back. The signature of the party is a guarantee, or it constitutes a certificate of the following after there is a reasonable inquiry. Number one, it's well grounded in fact. So if they're lying, they're violating Civil Rule 11. It's warranted by existing law or a good faith argument. If they don't have a law that supports what they're doing, then it violates Civil Rule 11. It's not interposed for any improper purpose, such as harass, delay, or increase the cost of litigation. Basically, abuse of the process. And then it says, for if attorney's helping and stuff like that. So they changed the rule here. Okay, here. If a pleading or motion or legal memorandum is in violation of this rule, the court on its own may impose on the person who signed it a sanction, or an appropriate sanction. So they can be punished for violating. So the substance of the rule is when somebody signs a court pleading, they're guaranteeing that they looked into it, that it's truthful, that it's not done for any improper purpose, abuse the system against somebody, delay or play games, and that if the attorney signs it, the attorney formed a reasonable inquiry or investigated it. And if the content of that declaration, affidavit, motion violates this rule, they can be sanctioned. The court can do it. You could say in the middle of a hearing, Your Honor, look what they said in their paperwork. I just proved that they're full of crap. I'd like Civil Rule 11 sanctions against them, $250 against the mother and $1,500 against the attorney. Or you could do a motion for sanctions afterward or whatever. So that's the generic of the rule. But not every state, Washington State has a Civil Rule 11, looks just like federal court. Not every state does that. So you want to find the one in your state. So this is how you. So Florida federal courts have Civil Rule 11 because the whole nation has it. But Florida state courts or district courts that you're in doesn't. So I'm going to look up. Remember the title of the rule is Civil Rule 11, signings of pleadings. And I'm going to throw in the word Florida and sanctions. So when I do this, bam, look at that. Sanctions, Florida, rules well, that's rules of appellate procedure, it looks like. So that's a federal rule again. And, okay, sanctions, Florida, rules of civil procedure 1.380. And this is failure to do discovery. So that's not it. So actually, here's an attorney's blog. And some of you guys might find blogs by attorneys. And then you have to find the rule in the blog. So there's statute 57.105 talks about, these guys are talking about sanctioning somebody. So I'm going to click on that. So sometimes you got to take a couple steps to find something. Attorney fees and sanctions. And then it talks about that something was not supported by material facts and application of existing law. So that's similar to Civil Rule 11. I think Florida has another civil rule, but I'm not sure. But let's look at another state for example. So on this one, I did New York signing of pleadings and did a search. I'm going to put the word sanction in there. And there's this. You see this New York Unified Court System? That's where a lot of New York stuff is linked and put together. So here we go. Costs and sanctions, part 130. This is the rules of the chief administrative judge. And you have subpart 130. And then it talks about awarding sanctions and costs and signing of papers. So it looks like the same language as Civil Rule 11. So in New York, the Civil Rule 11 equivalent is this 130-1.1a. And I'd be asking for sanctions every time somebody lies about that. Okay, and another example, we're going to do California signing of pleadings. And first things that pops up is California Code of Civil Procedure. If you see civil rules in there, and this pretty much looks like every pleading shall be signed or signed by a witness or an attorney. And it says the same thing. The claim is not frivolous. It's not being presented for an improper purpose. So there's your way to find. There's a way to find the Civil Rule 11 equivalent in your state. First, look at your state Civil Rule 11. If you don't find out, use this.